Good afternoon, everyone. My name is Sean Marshall. I'm the Regional Director with Region 5 of the National Labor Relations Board, with an office in Baltimore, Maryland, as well as one in Washington, D.C. Thank you for joining us here this afternoon, and it's my privilege to introduce Ann Hodges, who will be our principal presenter today, and I'll be moderating the discussion and also handling, fielding the questions and passing along those on to Ann. Of course, I'll also be contributing to the extent that I can. So without further ado, I would like to introduce Professor Hodges. Professor Hodges is the current interim program chair of Human Resources Management for the University of Richmond School of Professional and Continuing Studies. She is also a professor of law emerita at the University of Richmond, where she twice won the Distinguished Educator Award. Her academic focuses are on labor and employment law, feminist legal theory, and nonprofit organizations. She's the co-author of 2 books, one on public sector employment and 2 on principles of employment law. She's a member of the Labor Law Group, which is a group that develops teaching material for schools. She's also been elected to the College of Labor and Employment Lawyers. She previously practiced labor and employment law in Chicago, where she represented both unions and individual employees. And as a current NLRB employee, I'm obligated to say that Ann previously also worked for the NLRB at our offices in Indianapolis, Indiana, and Peoria, Illinois. So without further ado, Professor Hodges.
Thank you very much, Sean. And I want to thank Sean for agreeing to moderate today. It's a little bit intimidating to make a presentation about the National Labor Relations Act and the National Labor Relations Board to a regional director. So Sean is going to chime in because he's got the boots on the ground experience with all of what is happening and what I'm going to be talking about today. So he's going to be chiming in and adding that experience to what I can present. I'm going to take a moment here and share my screen. Okay. There we go. So we're going to be talking today. This is really an update on what's been happening at the National Labor Relations Board in recent months. And of course, as everyone knows, there's been a change in the board as a result of the election of Biden. And that's going to be part of the focus today. We're going to talk about the personnel changes and what has happened as a result of that. We're going to talk about cases where the board has formally announced that it's considering changes in the law. And then cases where there's some other sort of public position that has indicated a change. And John's really going to help me with that because some of those things are in like footnotes in cases and those sorts of things. And then in the last part, we're going to talk about some memos from the general counsel to the regions with respect to how to treat particular kinds of cases. And what this does is gives us some insight into what the general counsel is thinking about focusing on in terms of trying to change the law. And most of these memos or topics I'm going to focus on are ones that were in a memo that tells the regions to submit cases on these particular topics to the general counsel for advice before deciding whether to issue a complaint. And so those decisions would not be made by the regional director without consultation of the general counsel. And again, that tells us where the general counsel wants to have some input and is thinking about making changes. And most of what we're going to be talking about today are things where changes are anticipated for these reasons that I've just talked about. So when President Biden took office, he almost immediately fired the general counsel of the board, which was a pretty surprising thing to folks who have followed labor relations. over a period of time, because this has not happened before in all the years of the board. There was one instance where I think it was maybe President Truman asked for the resignation of the general counsel, and the general counsel resigned, but the general counsel has not been fired by the president. And so this, of course, immediately created an issue as to whether or not this was lawful. I'll talk a little more about that in just a minute. But also, of course, what has changed is the board. That took a bit more time because it's very clear in the statute that the president can't just terminate board members in the middle of their terms. What the president did do was appoint a different chair. That's Lauren McFerrin, and she was already on the board. She's a Trump appointee, but a Democratic Trump appointee. So she became the chair. Then there was one open Democratic seat that President Trump had not filled, which President Biden appointed a member there. And then in August of 2021, the term of Republican member Emanuel expired and another Democrat was appointed. So as of August, there now is a Democratic majority on the board, with the two Trump appointee holdovers, John Ring and Marvin Kaplan. So it was really only as of August of 2021 that the Democrats had a majority on the board. So there were legal challenges to this appointment of the new general counsel because of the termination of the previous general counsel. And a number of respondents argued in their cases that the general counsel didn't have the authority to issue complaints. And the board just ruled on that last month and rejected that argument and held that the general counsel did have the authority. So we have the board's position on that, and the case is up on the PowerPoint. I'm not sure how you pronounce the name of that case, Akash maybe. The board relied on a Supreme Court case, Collins versus Yellen. And in that case, the Supreme Court said when a statute doesn't limit the president's power to remove an agency head, we presume that that officer serves at the pleasure of the president. And when Congress includes particular language in one section of a statute but omits it in another section, it's presumed that Congress acts intentionally and purposely in that disparate inclusion or exclusion. So I said earlier, it's very clear in the statute that the president can't replace board members in the middle of their terms. That same language is not in the statute with respect to the general counsel. So that supports the board's position that the general counsel has authority. I am sure this will be appealed into the courts by this employer, if not others. And so we will see where that goes. So now I want to talk a bit about some requests for briefing that the board has issued. The chair of the board has indicated that she feels very strongly that when the board is thinking about changing the law, that they should get public input. And so she has indicated that where the board is doing that, thinking about changing the law, that they will seek briefing by parties and amici with respect to the particular issue. And they will, when they do this, they pose the questions that they're considering. This is different from what often happened under the Trump board, because under the Trump board, it was quite common, or at least it happened a number of times, where the board would change the law without asking for input, and even in cases where the parties weren't advocating for a change in the law. And there was some criticism of the Trump board for that, and it's clear that Chairwoman McFerrin is going to treat these issues differently. So I'm going to talk about these requests for briefing that have been put out by the current board. And you can find these on the board's website, along with the due dates for the briefs. So if anyone has an interest in submitting an amicus brief, those dates will be on the website. The first one is on the issue of bargaining units, appropriate bargaining units. And the name of the case is up there. American Steel Construction is the case in which the board's soliciting this briefing. And the question is whether the board case that came down from the Trump board, PCC Structurals, should be overruled. PCC Structurals overruled specialty healthcare, which came from the Obama board. And specialty healthcare had a standard that I think folks pretty much agree made it easier to organize very small bargaining units. And of course, it's easier for the union to organize smaller bargaining units. They have to organize fewer people and small numbers of workers that want to organize, if the unit is appropriate, can organize without the need to organize bigger groups. And the critics of this called this micro units. So specialty healthcare said that you look first to the unit that the union petitions for, and then you see if that's an appropriate unit under the community of interest standards. And if it is, then the other party, typically the employer, is going to have to show that any employees that aren't included in that unit have an overwhelming community of interest with the employees in the petition for unit in order to expand that unit. PCC Structurals overturned that standard and made it harder to find those smaller units appropriate. The PCC Structurals test says that the petition for a smaller unit has to have a community of interest sufficiently distinct from the excluded employees to warrant a separate unit. So you can see the difference in those standards. So that's one of the things the board's looking at changing. Now, just because they solicit briefs doesn't mean that they will necessarily change the standard. There are a number of examples where they have done this and then not change the standard. One recently was the Scabby the Rat issue, where the Trump board asked for input on whether they should find the use of Scabby the Rat in protest to be coercive. And ultimately, they kept the law the same and found that Scabby the Rat was not coercive. So that can happen as well. Just because they're asking for this input doesn't mean that this change will necessarily happen. Another one along that line is the issue of arbitration confidentiality. So many of you may know that the Supreme Court in 2018 rejected the board's argument that requiring employees to agree not to arbitrate or to arbitrate legal claims and to waive their right to class and collective actions didn't violate the National Labor Relations Act by prohibiting individuals from joining together to bring a claim. The Supreme Court said it's not an unfair labor practice to do that. This issue follows on that. And the three questions that the board has posed are up on the screen. First is, does an arbitration agreement that says you have to arbitrate all employment law claims that has a savings clause that says you can still go to the NLRB and file a charge, is that an unfair labor practice? Does that interfere with access to the board? And then the second question is whether the Federal Arbitration Act privileges a confidentiality provision in an arbitration agreement. So, I mean, looking at a provision that keeps an arbitration and the outcome of an arbitration requires the employee to keep that confidential, clearly interferes with the employee's ability to talk to other employees who might have that same issue and say, you know, I arbitrated this case, I won this case, here's how I did it, here are my witnesses. And so the argument is that that violates Section 8A1 because it prohibits the employees from joining together. And you know, the question is whether that's whether the Federal Arbitration Act privileges that provision. And then the final question is, well, if the FAA doesn't privilege it, what should the standard be for looking at those confidentiality provisions and deciding whether they violate the statute? So this is a way to, I think the board is thinking about, protecting employees in some way from these mandatory arbitration provisions, which are quite common these days, especially after the decision that allows employers to prohibit collective and class claims. So another request for briefing is the standard for assessing the legality of employer rules. And this is the Stericycle case. And looking at the Boeing case, which was decided by the Trump board. Under Boeing, the board rejected a previous standard, the Lutheran Heritage Village standard, for evaluating the legality of employer rules. And under Lutheran Heritage Village, most of the cases involved the question of whether a rule tended to reasonably chill employees in the exercise of their Section 7 rights. And then if so, the rule would be unlawful. And I think the board under the Lutheran Heritage Village standard was, I would say, maybe sympathetic to employees and how they might perceive these rules to interfere with their rights to engage in Section 7 activity. And in addition, Lutheran Heritage Village would find rules unlawful if they were used to interfere with Section 7 rights, and if they were promulgated in response to Section 7 rights. The Trump board came up with the Boeing standard, and the Boeing standard is much more deferential to employers and employer rules. And the board in Boeing said effectively, the Lutheran Heritage Village standard doesn't give enough weight to employer interests in having these various rules. And so the Boeing case came up with three categories of rules. Category 1 rules, the board said, were always lawful because either they didn't interfere with Section 7 rights if they were reasonably interpreted, or the employer's interest in having these rules outweighed any interference with the employee's Section 7 rights. And it proceeded in that case, and a number of subsequent cases defined certain rules to be always lawful. Confidentiality rules involving investigations, non-disparagement rules, no camera rules, civility rules, rules that prohibited moonlighting or outside employment. The board's categorized all these as always lawful. The second category is rules that you have to look at and balance individually to decide whether they're lawful. And then the third category is rules that are always unlawful. The one example that the board gave in Boeing was rules against discussing wages. So here the board is looking at whether to keep that Boeing categorization of rules and standard for evaluating the legality of rules. So again, they've asked for a briefing on this, looking at possibly changing it. Independent contractors and the standard for determining whether a person is an employee or an independent contractor is another one where they've solicited this input. The current case is Super Shuttle, and that lowered the threshold for employers to classify workers as independent contractors. And of course, if they're independent contractors, they're excluded from the statute and they have no rights under the National Labor Relations Act. What Super Shuttle did was to value the test of entrepreneurial opportunity. So if an individual had entrepreneurial opportunity that person is more likely to be classified as an independent contractor. Even if the employer structured the work so that that entrepreneurial opportunity couldn't really be exercised. And that was the case in FedEx home delivery, which was the case that Super Shuttle reversed. And just a couple of examples from that case. There, the FedEx drivers, and you've all seen those FedEx drivers that drive around and bring you your packages all the time now. They have to buy those trucks. They're classified as independent contractors. They're a very specialty truck with all these things inside. I don't know if you ever looked inside one, but it's set up perfectly so they can, get their packages and do it most efficiently. And FedEx said, well, you can use those trucks for other things. It's your truck. You can use it. And you can, run your little business in addition to working for FedEx. But the problem was the rules said you had to cover up the FedEx logo if you used it for anything else. Well, you've all seen those FedEx logos, right? Not so easy to cover up today and uncover tomorrow. And in addition, you had to have your FedEx truck at the FedEx facility at night so that it could be loaded and ready for the next day. And so the board looked at that and said, well, even though technically you have this entrepreneurial opportunity, all of these rules prohibit you from actually using that entrepreneurial opportunity. Super Shuttle says, hey, you got the opportunity, doesn't matter how limited it is, you're an independent contractor. So that's what the board is looking at in this independent contractor standard case where they've asked for briefs. Consequential damages is another one. And we'll talk a little bit later about some other areas where the general counsel is really looking to expand remedies. And remedies is an area where the statute's been criticized for a long time, that the remedies aren't sufficiently effective. And therefore, they don't deter misconduct by employers or violations, and they don't really protect employees. And so in this case, they're looking at the question of whether consequential damages should be included in damages. Right now, if a worker is fired for trying to organize a union, they get an offer of reinstatement and they get back pay. And that's it, pretty much. And a notice gets posted and some other things. Consequential damages would be damages like you got fired, you didn't have any money, you lost your house because you couldn't pay your mortgage payment, your house got foreclosed, you lost your car, was repossessed. The damages that flow from that, just getting your back pay 3 years later doesn't really cover all those damages that occurred because you lost your house or because you didn't have health insurance and you have a massive hospital bill. So those would be consequential damages. And the question is, should those be awarded in board cases? They never have been, but the statute does give the board pretty broad discretion in terms of its authority to remedy unfair labor practices. And so the questions the board has asked is, should they be covered? Should it only be where there are egregious violations, or should they be available in every case? And then what do you have to prove that these damages resulted from the violation of the statute? Okay. So those are the requests for briefing. We're moving to some other actions by the board and the general counsel. This one involves graduate students and whether they're employees. And as you may know, the board has flip-flopped back and forth with respect to that in the past few years. The most recent case is Columbia University. That was issued by the Obama board. And the board there said that graduate students are employees. The other position, which has been issued under Republican boards, is that these individuals are really students first. And they are not truly employees, and to find them to be employees would interfere with their academic relationship with the university. But currently the law is that they are employees. The Trump board proposed some rules that were in the rulemaking process. And those rules would have held that the graduate students were not employees, but were instead students. Those rules did not make it all the way through the rulemaking process before the board changed. And so those proposed rules have been withdrawn, leaving us with the law being Columbia University, graduate students are employees. And graduate students have been organizing a lot. It's an area of a lot of organizing activity. We've seen some strikes recently. I think both Columbia and Harvard graduate students went on strike recently. So a lot of organizing in this area and a significant decision. Excuse me. So joint employers, this is another area of rulemaking. This issue arises most commonly where an employer has a group of leased employees working in its facility. And the question is, are those leased employees employees of the supplier, the leasing company only, or are they also employees of the company that is in whose facility they're working? And there was a series of cases, and then the Trump board actually issued a rule on this. And this is a rule that got all the way through the rulemaking process. That rule requires that the user employer actually exercise control over employment conditions and not just have theoretical control. I'm so sorry. So that rule is in place, but the board has announced it will engage in rulemaking, another set of rulemaking. We don't know what that new rule will be. It could just revoke the old rule and return to the prior case law, or it could issue a new rule. So that's something that will be forthcoming. We'll be looking for that new rule. And it takes some time to write these rules. So it'll be, they just made this announcement recently. It'll be a little time before we see what that rule actually is, but they're clearly looking to change.
Before we proceed, Professor Hodges, I do want to flag two other notices of invitations for briefing that the prior board had issued that are still pending decisions. And those are number one, having to do with non-discriminatory maintenance and enforcement of an employer's uniform policy that would implicitly allow employees to wear some form of union insignia, such as a button. That's a case involving Tesla. The other is the standard for an employer's investigative efforts in preparation for a defense of an unfair labor practice charge, which is the long-standing Johnny's Poultry. Those were two invitations that came out under a Trump-appointed chairman, but the board has yet to rule on those or issue anything in that regard. In both instances, the current chairman, Member McFerrin, dissented from the invitation for briefing. So now that there's a Democratic majority board, the issue is still before the board and they haven't spoken on it, but obviously the composition of the board has flipped. But those are two issues which are outstanding and which I think you can legitimately expect to see some comment from the board.
Mm-hmm. Yeah, it'll be interesting to see whether they do anything, given that the invitation came from the prior board. Yeah, thanks for jumping in on that, Sean. You gave me a chance to drink some water and hopefully stop coughing. So I'm moving now to some memos that have been issued by the general counsel to the regions, sort of telling the regions, you know, what her position is on certain issues and providing some guidance about how the regions should proceed when these issues come up. One that's been in the news a lot is whether athletes are employees. And you may remember a few years ago, the Northwestern football players tried to unionize. Ultimately, the regional director at that time in Chicago, Peter Orr, who is now the deputy general counsel, found them to be employees of the university. The case went to the board, and the board did not decide the issue. The board decided not to exercise jurisdiction over college sports, essentially, for a number of reasons. One, that so many of the sports teams are from public schools, and so the board doesn't have jurisdiction over those public schools. That's certainly true in the Big Ten, or I guess it's now the Big 12, maybe, where Northwestern plays. And so the board just declined to exercise jurisdiction, a decision that was, praised by some folks and criticized by others as really at odds with the law. So that was just sort of standing out there. The general counsel, who was the current general counsel, was a deputy general counsel at that time. And of course, as I mentioned, the regional director, who found them to be employees, is now the deputy general counsel. So the position of the general counsel now, as contained in this memo, is that certain athletes, and I think we're talking about private schools, and we're talking about revenue sports, and we're talking about scholarship athletes, not walk-ons, for example, that the general counsel considers those to be employees. And she also noted that misclassification of these athletes by telling them that they're students and telling them that they're not employees and they don't have these rights could violate Section 8A1. It will be interesting to see what happens in college sports, because as you may have read, the Supreme Court issued a decision last term in the summer in Alston versus NCAA, and struck down a number of NCAA rules as in violation of the antitrust law. But the interesting piece of that was Justice Kavanaugh wrote a concurrence in which he suggested that many of the NCAA rules violate the antitrust law, and one way around that for the NCAA to keep its rules would be, and enforce them, would be through collective bargaining by athletes. So it will be interesting to see whether we see, in response to Alston, any sort of effort by college athletes to unionize, or maybe even some sort of movement on the part of the NCAA or some schools in that direction, in order to preserve the NCAA's authority to issue all these rules that are requirements for schools that they have to comply with. Another memo that came out from the general counsel focuses on protecting immigrant employees. The Supreme Court has ruled in a couple of cases under the National Labor Relations Act some years ago that employees that are undocumented, while they have rights under the statute, essentially they have no remedies because they can't be reinstated because of the restrictions of immigration law, and they also can't get back pay. So this memo focuses on protections for those immigrant employees, because obviously an employer who has undocumented workers really suffers no penalty if the employer discriminates against them under the National Labor Relations Act, because they have no remedy. I mean, they might get a notice posted, those sorts of things, but no reinstatement or back pay. So what the general counsel focused on in this memo was encouraging the regions, this is telling the regions how to handle these cases. First, they should facilitate these workers trying to get UNT visas, which are special visas that are given to immigrants who cooperate with law enforcement or immigrants who are victims of a crime, like human trafficking. The regions should take very seriously immigration threats, that is, employers that threaten employees, that they'll be reported to immigration, for example, if they try to organize a union or enforce their legal rights. She also suggested a number of remedies that the regions should look at that are kind of tailored to the situations of undocumented workers. One in particular that I thought was really interesting was requiring employers to actually sponsor these workers and try to get them work visas so that they can work legally in the United States. Also, it's important to focus on protecting witnesses in cases so that they will actually participate and testify, because they're obviously fearful of being reported to immigration. And then she encouraged the use of Section 10J injunctions. Those, as you may know, are preliminary injunctions where the board will go into federal district court and enjoin the violation pending litigation of the underlying unfair labor practice case. It's a discretionary provision. There are also injunctions under Section 10L of the statute in certain cases where unions are picketing. The agency has to go into federal district court and seek an injunction. Under Section 10J, they do not. And the use of Section 10J tends to fluctuate depending on essentially who's on the board, who's in the general counsel's office. We haven't seen a lot of 10Js under the Trump board, and it's pretty clear we're going to see more of them because the general counsel has issued a memo with respect to that too, and encouraged really aggressive use of Section 10J, encouraged the regional offices, if they think there's a case where 10J ought to be used, to expedite the investigation so that the injunction can be obtained quickly. And she identified a number of cases where it's difficult to remedy the violation after litigation. And these are the cases where she suggests to look to Section 10J to get those injunctions in place while the case is litigated. One is discharges in union organizing campaigns. When particularly a leading union organizer is fired during a campaign, if that person doesn't get back to work quickly, it will typically kill the union organizing campaign because it scares everyone else. And so the theory is you go in, you get an injunction, you put them back to work pending litigation of the legality of the termination, and that mitigates the impact on the union organizing campaign. Similarly, she suggests with respect to other types of serious unfair labor practices that would be the subject of Gissel bargaining orders, that is, remedies where the employer is ordered to bargain even if the union did not win an election. So those are only very serious or egregious unfair labor practices. In those kinds of cases, she suggests the use of 10J to sort of put things back in place, the status quo, while the legality of the action is being litigated. Post-certification violations, or what do we mean by that? When a union has won an election and is in the process of trying to negotiate that first contract, the data on those first contracts is shows that it's very tough for a union that wins an election to get that first contract. Once they get that first contract, it's pretty typical to get subsequent contracts, but it's hard to get the first one. And so the concern is these post-certification, pre-first contract violations are an appropriate place to use Section 10J. a withdrawal of recognition cases where you have an incumbent union and the employer withdraws recognition, arguing that it has a belief that the union no longer represents a majority. There are limits on how and when you can do that. And those are cases that she suggests the use of 10J to, again, maintain that recognition, require the employer to continue to recognize the union pending litigation of the legality of the withdrawal. And the final one, where she suggests 10J should be used more often, is refusals to bargain by successor employers. So when one employer takes over, purchases another business, there's a union in place, that successor, assuming it hires a majority of the employees from the predecessor, has an obligation to bargain. So in those cases where either the successor doesn't hire a majority of the employees, and the allegation is it did so in order to avoid the bargaining obligation, or where it hires them and refuses to bargain, the general counsel suggests those are cases where there should be efforts to use Section 10J more. So it seems pretty clear we're going to see a greater use of Section 10J injunctions under this general counsel. Remedies.
Before we go on to the remedies, I just wanted to touch a little bit on the memo discussing remedies for immigrant workers.
Okay.
And that's a very significant memo, and one that we take exceptionally seriously in a region. And while it's true that an individual who is truly and legally undocumented might not be able to access certain portions of a remedy, that determination is not necessarily something in which we're going to be making. And it involves quite a bit of investigation on our part and determinations from outside this agency. So generally speaking, we are going to be seeking full remedies for all individuals. One other aspect that I wanted to touch about that was the notion of U visas and T visas. There are other avenues which we collaborate with other federal agencies in order to facilitate the status of an individual who's in this country, such as deferred action. That would be something that would be distinct from they're actually getting a U visa or a T visa. But also the agencies that are involved in processing those have significantly changed their procedure and the methodology by which they make determinations, and that individuals may be getting what's referred to as a bona fide determination of their status significantly earlier than in the past. So their access to remedies, I think, is probably safe to say significantly enhanced over what it previously was. But as a region, I can tell you personally, we've been successful in working with individuals with issues and facilitating resolutions on their behalf that went beyond just the National Labor Relations Act.
Thanks, Sean. That's really helpful to hear how it's working in the real world. So I want to talk a little bit about remedies. As I mentioned earlier, the statute has been criticized, and the board, I think, for not having very effective remedies. So we see a memo from the general counsel focusing on that, and prior general counsels have tried to do this as well. So far, no one's been successful. One I remember back in the probably early 2000s was Leonard Page, and he tried to do some of these same things. These are also remedy enhancements, I think, are in the PRO Act, which has been introduced in Congress, has actually passed the House, but is highly unlikely to pass the Senate, and it has a number of reforms to the statute. I think some of these remedies are also in the Build Back Better Act. Again, whether that will actually pass or not, we don't know either. So back to the general counsel's memo, it's pretty clear, as I mentioned earlier, that the statute gives some broad discretion to the agency in preventing and remedying unfair labor practice. And the General counsel encourages the regions to seek remedies that will fully address the harms that flow from the violation. In discharge cases, she recommends the consequential damages, which we talked about earlier, front pay. So if an individual decides not to seek reinstatement, she's encouraging as a remedy front pay into the future to account for not accepting reinstatement. And lots of workers don't want to go back to the place that they were fired. So it is not uncommon for a worker to refuse reinstatement even when it's offered. Then we talked a bit earlier about the undocumented worker remedies, so I won't go through that again. In terms of organizing campaigns, she encourages the use of remedies that give the unions greater access to the workers. So the ability to go into the workplace and talk to the workers, giving the union employee contact information so they can reach out to the workers, have a way to get in touch with them, reimbursement of organizing costs to the union, and various efforts at sort of enhancing the notice to employees of their rights. So having the employer or sometimes somebody from the board read the notice to employees, doing a video of the notice, various ways to use those notices or highlight the notices and make them more effective. I don't know if anybody's ever seen the movie Norma Ray, but there's a scene in there where there's a notice and the union's able to come in and inspect it, and it's covered by all sorts of other papers. And so that sometimes happens, or employees sometimes just don't read those notices up on the bulletin board with a bunch of other stuff. So the idea is sort of enhancing the notice. And these are all remedies that have been used in the past as enhanced remedies where there are particularly egregious kinds of violations. And then in bargaining cases, the remedies that are suggested are, and again, some of these have been used in the past. These are cases where the employer has engaged in some bad faith bargaining. So setting a bargaining schedule, requiring the parties to keep to a bargaining schedule, requiring them to make progress reports to the agency as to how they are progressing in bargaining. And this last one was actually in the advice memo that I mentioned earlier. It's a suggestion that they look at make whole remedies for employees. This is something the board looked at back, I think, in probably the 1970s. And what it would involve is looking at a situation and saying, well, if the parties had bargained in good faith, they would have, agreed to higher wages. They would probably have agreed to higher wages and better benefits. So we're going to reimburse the employees for what they lost by not getting those higher wages and better benefits. Ultimately, having looked at that and having at least one court of appeals say that the board had the authority to do that, the board decided not to issue those remedies. And again, this is an effort to look at that again and see whether that might be an effective remedy for bad faith refusals to bargain, because what you often see in those cases is the board finds bad faith bargaining. The remedy is go back and bargain again. And so then maybe you see some more bad faith bargaining. So very easy for that to drag out over a period of time and for the remedy not to be very effective, because it basically is go back and do what you didn't do already. There's also a memo.
Before we go on, I think it's important to recognize that there are two different memos on this subject. GC 2106, which was the previous slide, that's what you can legitimately expect to see in my complaints. I issue the complaint, which initiates the litigation process. If we haven't settled the case up to that point, those are the types of remedies that you could expect to see me seeking in the complaint that I issue, and then we litigate before an ALJ and then before the board. The slide that we're going to talk about now are remedies that you can legitimately expect to see in a settlement proposal from a regional office. Two slightly different constructs there.
Mhm. Yeah, and this one, agency is going to be looking for 100% of back pay and benefits and the front pay that we talked about a bit earlier. I think, I don't know, Sean, maybe you can jump in on this, but my experience back when I was at the board and practicing before the board was the board would almost always take 80% back pay in settlements.
The rule, I think it was at one point in time written in the case handling manual. But I think that how shall I put this? The very strong guideline was a regional director could accept unilaterally a settlement offer that included an offer of reinstatement and 80% back pay. If there was no offer of reinstatement, there would have to be some sort of determination that the individual had forfeited their right to reinstatement. But if you got over the 80% threshold and an offer of reinstatement, that was a settlement offer that a regional director could take unilaterally and feel very comfortable that the general counsel would deny any appeal.
Mhm. Okay, good, that's helpful. And the second one here is some of the consequential damages that we talked about. So loss of health insurance coverage, damages from that, loss of the home, the car. We talked about that earlier. Letters of apology. I thought that was really interesting. I don't know, Sean, maybe you can comment on whether this is common, but sorry about the noise in the background. I have not seen those. And the idea from reading the memo was that employees might be more likely to accept reinstatement if they got a letter of apology from the employer. Is that something new?
That is something that's very new, that has really only come into existence with 2107, and it's precisely in those situations. And just to dial back to an overall remedial aspect of it, in situations involving a failure to hire or a discharge or some sort of situation in which an individual is denied employment with the respondent employer, the principal remedy that we're going to be seeking is reinstatement. That's the goal. It's the situations in which there's a mutual desire to not employ the individual or for the individual to not go back. Those are the situations in which we're going to be seeking at a minimum 100% pay, but in all likelihood 100% pay plus front pay. But the letter of apology is designed, the theoretical underpinning is, this is a way to ameliorate the individual's feelings when they go back to employment with the employer that committed some form of unfair labor practice in failing to hire them or discharge them.
So moving on to a couple of these other ones, inclusion of a default provision in the event of non-compliance. And this is basically a provision, as I understand it, that if the employer breaches the settlement agreement, or the party, could be a union as well, that they are essentially waiving many of their defenses to the complaint. Is that an accurate description of it, Sean?
That is an accurate description, and this is an issue that has gone back and forth between administrations. And in my experience, whenever we would explain what this actually meant to a party that wanted it stricken, they didn't seem to have as many issues with it, because as you pointed out, the whole underpinning of it is, if you breach this settlement agreement, this is what's going to happen. We will file, you will have waived your right to file it. We will issue the complaint or reissue the complaint, and you will not really have the opportunity to answer that. That's the quid pro quo for us not moving forward with the litigation. Once it's explained to them that this only exists, this only comes into a play if you, number one, we think you breached the agreement. Number two, you don't cure it after an opportunity to cure it, and then it's found that you have actually breached it. It only comes into play in those situations. Typically, parties do not enter into a settlement agreement with the idea of breaching it. So once that's explained to them, they were not oftentimes as interested in having that language stricken.
And similar to that, they mentioned the expanded use of security provisions. So efforts to secure the ability to actually obtain the remedy. So various sorts of security interests, I think, to prevent the employer from, filing bankruptcy or transferring assets or doing other sorts of things that would prevent the collection of the remedy. And then it also mentions that non-admissions clauses should be rare. Those are clauses that will be included in the settlement agreement that basically say the respondent doesn't admit that it violated the law. And I think this is suggesting that those should not be routinely incorporated into settlement agreements, but only in rare occasions.
I'll go a step further for everybody on the call, which is the memo actually not only discourages the use of non-admissions clause, but encourages the use of admissions clauses, which one of the things that we would commonly tell parties involved in settlement negotiations is signing the settlement agreement is not an admission of wrongdoing. Now, under the GC 2107, we are encouraged in some situations to include that admissions clause where a respondent or charged party admits to having violated the National Labor Relations Act, which can be useful in certain situations involving recidivist entities, either employers or unions who we see repeatedly violating the law. Having that admissions clause is a valuable mechanism, not only for deterring anything future, but also it's a way to get more stringent remedies against that entity in the future. Because what we typically look for is a grading up of remedies, so that the next time that entity violates the act, we can point to they have it. Not only do they have a history, they've admitted to having a history of violating the act.
Great. All right, I'm going to move on to the next slide. I'll talk a couple minutes more. I have several more slides, and then we'll stop and see if folks have questions. So this last part really focuses on the memo to the regions in identifying the cases in which the regions should go to the general counsel before deciding whether to issue a complaint. There are several of these. I'm going to go through these really quickly, and then if folks have questions about them, we can come back and talk about them during the question and answer session. So one involves jurisdiction over religious employers. The current law basically sort of the standard says that there is no jurisdiction. The board will not exercise jurisdiction over religious schools. It's where most of these have arisen. So that's one issue. Misclassification of independent contractors and whether or not that is a violation to actually misclassify an employee as an independent contractor. Protection of collective action, sort of what are the standards for what's concerted and what's for mutual aid or protection. And then the burdens of proof in these cases. There's a Trump board case, the General Motors case that changes the standards for finding a violation in these cases where an employee used to be that you would look to see whether the employee did something that lost the protection. The manner or means in which the employee engaged in collective activity was so egregious that they lost the protection. Now the board is using this but-for test that's used in Section 8A3 cases to determine whether employees are protected. It's much more difficult, frankly, for employees to get that protection, in my view, and Sean may have a comment on that as well. But and then Weingarten rights for non-union employees is another one. What is solicitation versus just talking about the union, because there's particular rules for solicitation and employers can ban solicitation under some circumstances. Access to employer.
For a few of these, for a few of those bullet points, I just want to let everybody know that the general counsel has taken the position in publicly available and filed briefings to reverse or overrule or modify current board law. And that those are cases in which it's involving the General Motors, which the idea was to go back to the Atlantic Steel framework that Professor Hodges mentioned, as well as some of those other cases that go towards what exactly is involved in showing animosity towards employees' protected activity or union activity. Shig-free, Electrolux, those cases, the general counsel has already taken positions seeking to overrule, reverse, or refine those.
Great, thanks. And then, access to employer property. This is an area where we've seen a lot of action and decisions in recent years. And I feel like my description of this is a lot of it seemed to be converging around the notion of, are there other ways to get this access? And if you can't show there's no other way to get access, then you can access the employer's property, whether it be the physical property like the land, whether it be the email systems and those sorts of things. That seemed to be the direction that I think the cases were moving. And clearly the general counsel seems to be identifying these as cases that she wants to look at in terms of, when can contractor employees, for example, protest on the property where they work? When can union officials go into some sort of public place and engage in activity like a restaurant and talk to employees if they're just sitting there like other patrons of the restaurant? What's discriminatory access? So an employer can have a rule, but if it prohibits union activity but allows other activity, similar activity by other charities, for example, if it allows soliciting by charities but not by unions, is that discrimination under the law? And the rules have changed some on that, and the board is sort of saying, well, it has to be very similar. It has to be essentially like a union in order to be discriminatory. And then employees now have no right to access the employer's email systems for union activity. That changed under the Trump board. So looking at that issue. And then, and I think this is the last slide, sort of in the area of collective bargaining, the make-whole remedies that I mentioned. Waivers of bargaining rights. So the Trump board came down with the contract coverage standard. It's waived if it's covered by the contract. The standard used to be clear and unmistakable waiver. So looking at that issue.
That's also an area in which the general counsel has already taken the position to go back to clear and unmistakable waiver and overrule / refine MB transportation.
Okay, thanks. Then the refusal to recognize, and this is, I think, kind of a longstanding rule, but the general counsel seems to be looking at it. So if the employer refuses to recognize a union based on a card majority, but doesn't really have a good faith doubt, and then the employer commits some unfair labor practices or didn't really have a reason to doubt it, is that a violation? And I think historically it's been, you can just say, no, I don't want to, go file a petition. Not going to recognize you. So that's something that the general counsel is looking at. And then the last one on here is, what triggers the requirement that the employer furnish financial information to the union? And it's been claims of inability to pay. And this question that the board has gone back and forth on is, if the employer says, well, they don't say exactly inability to pay, they say we're at a competitive disadvantage, does that trigger the duty to furnish that information? So I'll stop there and see if folks have questions for us. You can either put the question in the chat or just use the raise hand function or jump in. I'm going to actually,
Comment from Mr. Arthur Pearlstein. Thank you. A terrific presentation. I don't know if you can see this, Ann. Terrific presentation, Ann. Great information.
I'm going to try to stop sharing here and then maybe I can see the chat. Having some trouble with my computer.
Yeah, this is obviously a new board and a board that is really in its infancy as a Democratic majority board. But you do have the obvious issues that are teed up, those of which they've already provided the notice of invitation for briefing. And there are a number of other issues in which the prior board took in a different direction from existing law at the time. And I think that those are legitimately ones in which you can expect to see further invitation to file briefing. One thing that, for practitioners, a lot of times you end up seeing a flurry of board decisions at particular times of the year. Not coincidentally, that is often as a board member's term expires. So the next board member expiration would be John Ring, who is a Trump appointee, and his term expires, I believe, December 16th or December 18th, 2022.
And there are a number of other issues that were in the advice memo as well. That there just wasn't time to fit in the presentation, but there's some additional ones also. And you can go on the board's website and see all of these general counsel memos, and they're very accessible. And you can look to see whether they're, you might want to file a brief. You can see the deadlines for filing the amicus briefs on some of these topics as well. Any other questions, comments? Anybody have an experience that they've been through that might provide some insight for other folks? We'd love to hear those as well. I mean, one thing I would just say about these sort of flip-flops is they have increased in recent years, I think, and we see more of this as we see, the polarization in our politics generally plays out as well, I think, at the board now. And it wasn't until, I think, 1975 was the first time a partisan, a management person or a labor person had actually been appointed to the board. Before that, the board members tended to be neutrals. But kind of once that started, I feel like it broke the dam a little bit. And then we saw more, even the 80s during the Reagan administration, some very partisan management folks. And then we moved into the Clinton administration and we saw the first appointments of people with labor backgrounds to the board. And now that seems to be what it is, right? It's the management folks and the labor folks and not neutrals that are being appointed to the board. And so, for years, the same people would be reappointed by Democratic and Republican administrations. We don't see that now either. So there's much more, partisanship in this area, just like there is much more partisanship in our, politics and government in general. So we see more of these shifts, and I feel like we've seen more. For a while, there were a few areas where it went back and forth, and now those seem to be expanding. And we see, under the Trump board, some, areas that have been stable for a very long time, and we saw changes. So I think, unless something really changes in our politics, we're going to see that same pendulum and back and forth, and it must be really interesting to work in the system. With the
No,
right
I
whiplash.
I agree with that characterization, and as the regional director, I can appreciate the position that oftentimes, and it's going to be predominantly employers, but also unions, to the extent that they're conducting their business, their ability to rely on what is current law, and the challenges that face when there's a change in administration and a memo comes out. But I do think that there is a recognition that, and I'll use the hypothetical employer here, a hypothetical employer who is acting consistent with now current law, and there are no other violations, and their actions would be lawful under current law. I think that there's a real recognition of those do not present really good vehicles for litigating unfair labor practice complaints against that employer, because they're acting in reliance on current law. Now, in situations in which it would be a violation under current law or a change in law, or situations in which there are a number of other violations, that presents a different issue as to whether or not we're going to proceed to litigation.
Any other questions from anyone or comments? Well, thanks everyone for coming.
Thank you.
Appreciate you being here. We would encourage those of you who are not members of the Virginia Lera chapter to join the chapter. We're a new, relatively new chapter of Lera, and we're excited to have a Lera chapter in Virginia and hope to keep offering more of these programs. And if you are a member, let us know what you're interested in seeing in terms of programming, because we'd love to have your ideas.
Thank you, everyone. Have a wonderful afternoon.